Mrs. Bailey was involved in a motor vehicle accident where another vehicle crashed into hers as she was crossing an intersection. She had ongoing pain in her neck and back and was restricted in her ability to work and also in her ability to continue participating in sports. When the matter came to court, the judge observed Mrs. Bailey while she was in the courtroom. Now, it's uncontroversial that a judge or jury are entitled to take into account their observations of a witness in the witness stand. They're allowed to consider things like body language when assessing evidence. We divide evidence roughly into three types: oral evidence, documentary evidence, and real evidence. Witness demeanour in the courtroom is a form of real evidence because it's really there. The judge and jury can directly observe it. President of the Court of Appeal Kirby said, "The appearance of a witness as he or she approaches the witness box may properly be taken into account where agility and ease of movement are in contest. To require otherwise would be to require a division of the mind quite unrealistic in the case of a jury and equally artificial for judicial officers." The thing is, though, it's a fundamental rule that any evidence to be considered in a case should be identified for the parties so that the parties can make submissions about what conclusions the court should draw in relation to that evidence. That happens automatically when the witness is observed on the witness stand. Everyone's watching. But in this case, the judge also considered his observations of Mrs. Bailey while she was seated in the back of the courtroom, waiting for her matter to come on. President Kirby said that in such a case, there should be notification to the parties and their representatives where the observations have occurred, as here, outside the actual period of the trial, and where the person observed is at the back of the court behind the representatives of the parties who thus have no opportunity to observe the features in question, and by interrogation, evidence or advocacy to persuade the decision maker to a different view about them than has been formed. As a result, while it was perfectly fine for the judge to make observations of Mrs. Bailey, those observations should have been disclosed to the parties. They were not, so the trial miscarried.